All right, I'm going to call to order the meeting of the Sentencing Guidelines Commission. It is February 9th, 2023, and we are conducting this as a hybrid meeting as per state law. Nate, so if you wouldn't mind taking the roll.
Roll call, Estrada. Estrada absent. Ibrahim.
Here.
Ibrahim present. Knudsen.
Here.
Knudsen present. Ladd. Ladd absent. Larkin.
Here.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore. Moore absent. Morath.
Present.
Morath present. Schnell.
Here.
Schnell present. Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 7 members present, 3 members absent, 1 seat vacant.
All right, and with that, we have a quorum. The first item on the agenda is approval of the draft meeting agenda. So I would entertain a motion to approve the agenda. So moved. Commissioner Larkin moves to approve it. Do we have a second? Commissioner Middlebrook. Any discussion? Hearing none, we could read the roll there.
To the Larkin motion to approve the agenda, Estrada. Estrada absent. Ibrahim.
Say that one more time, sorry.
This is to the Larkin motion to approve the agenda.
I second that.
Ibrahim, yes. Knudsen.
Yes.
Knudsen, yes. Ladd. Ladd absent. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell.
Yes.
Schnell, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed, and Commissioner Moore is not present.
All right, great. With that, the motion is approved unanimously and we'll recognize.
Yeah, Knudsen voted aye, right?
I believe so.
Somebody.
Yes.
Oh, you
Somebody
did not.
answered for me.
Oh, someone answered for you?
Or they skipped it.
That's awful. On this important vote?
I know.
I'm sorry. I had Knudsen as a yes on my spreadsheet, so I don't know what happened.
That's fine.
Okay, so you are voting aye.
Probably before they did.
Okay, excellent. Thank you very much for correcting that. Okay, so with that, the motion is approved unanimously to approve the meeting agenda. And then the next bit of business is to approve the draft meeting minutes from January 12th, 2023. I'd entertain a motion to approve the minutes.
So moved.
Commissioner Larkin moves. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion on the minutes? Hearing none, take the roll.
To the Larkin motion to approve the January 12th, 2023 meeting minutes, Estrada. Estrada absent. Ibrahim.
Yes.
Ibrahim, yes. Knudsen.
Yes.
Knudsen, yes. Ladd. Ladd absent. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell.
Yes.
Schnell, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
Great. With that, the minutes are approved. The motion is approved unanimously. All right. So moving on to the rest of the agenda for today. So the commission is still in a little bit of a holding pattern. The governor is expected to make appointments in the next month or two to the commission. So then we'll know for sure who the membership is going forward. And so in that time, I didn't think it was a good idea to take up too much that new members should be involved in if there are any new members. So the agenda today is mostly, the first item is an action item, or the fourth item is an action item, but it's something that I think the people that are here can handle. And then the rest of it is a little bit to sort of keep one of the topics moving, to give the staff some direction on what sort of information we might need to continue our discussion of prostitution. And then we're in the midst of the legislative session, so we will definitely touch on the issues that relate to that. But we're not at this moment taking up too many big picture items or too many big ticket items. because we want to make sure that we have a full commission before we move forward with too much. So with that, against that backdrop, the first item that we are going to work on that's substantive is updating the demographic impact statement policy. That's relevant because we are in session and our staff is producing demographic impact statements, I hope, from time to time. And we sort of put off finalizing this work last fall. I'm going to turn it over to Nate to walk us through it, and this is on as an action item today.
Thank you, Madam Chair. And if I could begin with an announcement for the commission, and that is I am required under our current demographic impact statement policy to notify you when we have a demographic impact statement that we're anticipating preparing. We currently have 3 bills that meet the significance criteria for demographic impact statements. And those bills we'll be talking about in a little bit. One is the cannabis/marijuana bill, which I'm reasonably confident we can prepare a demographic impact statement based on how we did the analysis on where those prison beds are. In this case, it's a savings of prison beds, but who are the occupants of those prison beds that will not be occupants in the future. The second bill is organized retail theft, which has a significant prison bed impact, but based on how we got there, I'm not sure that we'll be able to estimate the actual demographic impact of that. And the third bill, which you don't have in your meeting materials, has to do with changing the state of mind that's required for conviction for somebody who aids and abets a felony murder. And that we just did we did the fiscal note on this morning, and it does appear that it's going to meet the significance threshold because of the amount of prison beds. That would also be a reduction in terms of somewhere in the high teens prison beds. I don't know whether we'll be able to do an impact statement, but under the current policy, the commission has the opportunity to participate in that process and let me know if you want us to run the demographic impact statements past you. So if that's something you're interested in, please let me know, and I'll follow up with an email since not all commission members are here today. But just to let you know that will be coming. So this is this is the demographic impact statement policy. This is on for an action item. This has come before you before. Let me just share my screen. So most of these changes, there are several changes here that have to do with, I would say, sort of editorial changes, not really significant policy changes. You'll see that in the first page. At least I don't regard them as significant changes, but you have had a chance to review them. Perhaps you have a different perspective. No real changes on authority or when these are prepared. We're not suggesting to change the significance thresholds. To remind the commission, the significant thresholds are either 10 prison beds plus or minus, so that there would be a reduction in the amount of prison beds that the Commissioner of Corrections would need by either 10 beds or an increase by 10 beds. The other significance threshold is 50 or more felons convicted each year. So for example, if a crime changes a gross misdemeanor to a felony and there would be more than 50 people a year convicted of that new felony, then that would meet that significance threshold. So we'd be looking in that case probably at the demographic. We'd be comparing the new felony population to the existing felony population, demographically speaking. In the scope section on page 3, we're tweaking that just a little bit so that it's either the demographic impact statement is requested by the legislature, which doesn't happen that often. Typically, it's initiated by the commission staff. So that's the second one. MSGC staff become aware that a proposed crime bill satisfies the significance threshold described in the prior paragraph. And that's essentially done when we do our fiscal notes. And not to get ahead of it, but we'll be talking about several bills where we've been asked to do fiscal notes. essentially, we're asked to do fiscal notes on any significant crime bill that could change the prison population. So that works out pretty well, because as part of that fiscal note process, we estimate how many people are going to be taking up prison beds, so we will know whether or not it satisfies a significant threshold. So that's, I don't think, really changing the intent of the demographic impact statement policy much. And then we get down to the process for doing it, and this is really where there's substantive changes. At the beginning of each annual legislative session, what this policy would do is just give you pose a general question to you. Kind of what I did is that, hey, you have an opportunity to participate in this process if you wish. You can review and comment on any demographic impact statement that are prepared. Then we will attempt to, so giving us a little bit of wiggle room here, but attempt to complete each draft demographic impact statement and forward it to all requesting members not later than 7 days before the next scheduled or anticipated committee hearing or legislative action on the bill or its companion. And then you'll have the right promptly, so it takes out that 3 business days. Sometimes we don't have 3 business days. Sometimes these are very tight timelines, and essentially if we don't get the demographic impact statement done within a relevant time period, it's useless for its intended purpose, which is to inform the legislature before it's too late. And what the legislature does with this is really up to them, but to the extent that it's valuable to them, and I know some legislators do consider it to be valuable information, it doesn't have any value if it's done after the legislative process is done. So the timelines are really changed to promptly, so that the requesting member will have the right promptly to propose changes, and staff will just promptly discuss those proposals with the requesting members and seek to resolve the issues pointed out before the statement is proposed to the legislature. It gives me the authority to shorten or waive this review process and its timeline if necessary to get the demographic impact statement to the legislature before the next hearing or legislative action. But there's also sort of a catch-all at the end where it doesn't become final until it's presented to the commission later on. So there's kind of a check and balance in that process as well. And we'll get to that in a minute. But after the review process is complete, and this is another change, the completed demographic impact statement will be submitted to the chairs and ranking minority members of the standing committees in the House of Representatives and the Senate, with basically the crime committees, the House and Senate crime committees, and the chief House and Senate authors of the bill and its companion. And if there was a legislator who specifically requested the DIS, then to the legislature and to the commission at its next meeting. So this is a change. It used to just be to the chair. So now it's to the chair and the other party and the author and the commission. So it's spreading it out to different people. This really came about when we had an author, Representative Pinto had found a demographic impact statement on our website and said, hey, it would have been really nice if I had known about this during the legislative session. Well, we sent it to the chair of the committee, but that chair apparently did not pass it along to Representative Pinto. Maybe I shouldn't be naming names here, but I don't know what the process was, but I know that Representative Pinto had expressed interest in receiving that demographic impact statement as the author of the bill, and that seems reasonable. So we're putting that in here as well, where the author and both parties in both chambers all get a copy of the demographic impact statement. So it spreads it around. And then there's a paragraph here. Oh, and then we have this sentence at the end, no change here, but just that's kind of the check and balance I was talking about. The issuance of the demographic impact statement is not final until it's presented to the commission. And then once it's presented to the commission and the commission doesn't take any action on it, then it does become final. But the commission has the right, if it objects to it, to do so at the meeting. And I will say, when this demographic impact statement was prepared, and it wasn't by really this commission, it was by essentially your predecessor commission, I think there was some concern about what was going to go into the demographic impact statement and that sort of thing. In practice, we really haven't seen any controversy with the demographic impact statements. I mean, it's pretty straightforward. We're not trying to, we're just presenting facts and data, basically. So it hasn't really engendered the controversy that perhaps your predecessor commission might have anticipated, but I think it is good to have the check and balance. So we haven't had the commission really object to how we're preparing the demographic impact statements to fight, despite these opportunities for them to do so as presented in the policy. This last paragraph highlighted in yellow is new, and it basically allows us not to do a demographic impact statement if it's just not viable. So if the bill is dead, we don't have to do a demographic impact statement. But if we don't do a demographic impact statement for whatever reason, this paragraph also requires us to write up a memo, which is consistent with current practice. We write up a memo for our file, which is subject to public disclosure if a member of the public is interested in it, that explains why we didn't do a demographic impact statement on a particular bill. And we have had that happen where I've had questions about particular bills and people say, hey, why didn't you do a demographic impact statement on the bill? Sometimes it's because it didn't meet the significance threshold. Other times it's because we can't really give it a scientifically defensible estimate of what the demographic profile of the new prisoners or reduced prisoners or so forth would be. And then there's a history section that just talks about the sort of the history of the demographic impact statement policy. And that's it. So this is, I think, ready for your approval. If you're interested in approving it, it's written on the assumption that you'll approve it today, and then that would explain the 2/9/2023 here in the version 2.1 date.
I'd move approval.
Okay, so we have a motion by Commissioner Schnell. Is there a second? Commissioner Middlebrooks seconds. Any discussion on the motion? I think your changes look good. There's my discussion. And I think it's important that we pass it today, because one of the things that it does is speeds up the timeline for the staff so that they can be more flexible and responsive to the legislative session as well. All right. With there being no further discussion, let's go ahead and take the vote. There's a motion to approve the revised policy.
To the Schnell motion to approve version 2.1 of the demographic impact statement policy is drafted by staff. Estrada absent. Ibrahim,
Yes.
yes. Knutson,
Yes.
Yes. Ladd absent. Larkin,
Yes.
yes. Middlebrook,
Yes.
yes. Moore,
Yes.
yes. Morath,
Yes.
yes. Schnell,
Yes.
yes. Chair Mitchell,
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay, so item 5 is a review of prostitution offenses. We're going back to that discussion. Nate is going to reorient us to this issue, which we had some discussion on last fall as part of the comprehensive review of sex trafficking. As you are listening today, what I really put to the commission is what we're trying to figure out is, where do we want to go next? Do we have the information that we need to start to make some decisions on these issues? Or are we still lacking information? Is there something else that would be helpful to the commission? If so, then we would need to give some direction to staff as to what those next steps should be. So I'll turn it over to you.
Thank you, Madam Chair. So as you queued it up very nicely, Madam Chair, this is something we've looked at before. You have a paper in your your packet that explains all these issues in great detail. This is an overview presentation that discusses it. The paper is kind of a merging of parts of a few different papers that we presented last year, but we presented them in the context of the sex trafficking review. So these papers essentially take out everything that has to do with sex trafficking. That review is done and just deals with prostitution.
Oh, Commissioner Larkin.
Just a quick question. Is this something the legislature has asked us to do, or is it something that was related to our work on sex trafficking that we identified as something that would be worth exploring?
It is the latter case.
Got it. Thank you.
And I was just about to talk about that. Thank you for that.
Sorry.
Thank you. No, that is an
That
excellent
was my
segue.
memory. I wanted to make sure.
No, an excellent segue. So in 2021, the Central Minnesota Human Trafficking Task Force, which is, kind of out of the St. Cloud area, proposed a bill to the legislature, House File 613, that amended sex trafficking and prostitution laws and asked the commission to review its sex trafficking guidelines. I think it's important to remember that that's the task force that proposed this, because that's also the task force that suggested that we expand our review to include prostitution. So even though the statute that they proposed only said that we had to review our sex trafficking guidelines, it actually, I think they probably intended that we also look at prostitution. So that bill, House File 613, did pass, not during the regular session when House File 613 was proposed, but it passed as part of an omnibus public safety bill in Chapter 11, Article 2, along with a number of other changes. And the Central Minnesota Human Trafficking Task Force had some very specific ideas about changes to the sentencing guidelines. Jill, is there any way we can move our inset picture so the commission members in this room can see the slides better? Okay. So not all the changes were limited to sex trafficking. Some of the changes did pertain to prostitution. And we'll talk about what those recommended changes are going to be. But based on the proponent's intent, the commission did informally expand its sex trafficking review. I don't know that there was ever really a vote on that, but it's something that you sort of assumed and inferred from the commission's behavior that it intended to do that. If it doesn't want to do that, it could just say stop and we'll stop. That's fine. But so in 2022, you did complete your mandated sex trafficking review, and in your report to the legislature, you did indicate your intent to focus on prostitution this year. So what are the offenses that we're talking about here in terms of patrons of prostitution? So, or in terms of prostitution offenses. So there's two categories of offenses, and these are technically not the only prostitution offenses that are out there, or felony prostitution offenses, but it appears that these are the only offenses that the commission or the Central Minnesota Human Trafficking Task Force is interested in talking about. The others have to do with prostitutes, and the focus seems to be more on patrons of prostitution. So the first offense is patrons of prostitution. This is a new felony that was created in 2021 as part of this legislative change. It was prostitution was a misdemeanor. It was a gross misdemeanor committed in a public place. This made prostitution by a patron to be a gross misdemeanor at its base level. And then if repeated within 10 years, the offense becomes a felony. It's a felony with a 5-year statutory maximum. The commission in 2021 ranked it on the standard grid at severity level 3. So that's a fairly recent decision to rank this offense on the standard grid at severity level 3. It basically did that because if you skip ahead to the other half of the slide here, you'll see that minor engaging or hiring a minor to engage in prostitution, if that's ranked as that 5-year offense is also ranked at a severity level 3. So the commission ranked this offense the same way. So moving ahead to that offense, engaging or hiring a minor to engage in prostitution or child prostitution, as some refer to it, that the offense is, like the title implies, either engaging in prostitution with a minor or hiring for sex someone reasonably believed to be a minor. Technically, engaging in prostitution can either be done by a prostitute or by patron. So technically, it could be a prostitute having being hired by a minor patron, or it could be an adult patron engaging a minor prostitute. The statutory max and severity level ranking vary by the age of the minor involved. If the minor is 13 and under, it's a 20-year stat max that's been ranked at a severity level 9. If the minor is age 14 and 15, that's a 10-year stat max that's been ranked at severity level 5. And if the minor is 16 and 17, that's been ranked at severity level 3. It's a 5-year stat max, as I said. And there is a little wrinkle there with, there was a legislative error on one of the citations to age 13 and under, and the commission did recommend that the legislature fix that. No bills right now to fix that, but that's an open recommendation. So the Central Minnesota Human Trafficking Task Force had 2 recommendations with respect to prostitution offenses. One is to re-rank these prostitution offenses on the sex offender grid. So right now they're ranked on the standard grid. And I talk in the paper quite a bit about what makes an offense go on the sex offender grid. Basically, not surprisingly, it's if it's a sex offense, with one exception, and that is failure to register as a predatory offender. The commission recognized that wasn't a sex offense, but it saw good reason to put it on the sex offender grid anyway. So the proposed rankings are severity level 9. The severity level 9 offense would go to severity level B. The severity level 5 offense would go to severity level F. And the severity level 3 offenses, so patrons of prostitution and involving a 16 and 17-year-old victim, would go to severity level G under the Central Minnesota Human Trafficking Task Force recommendations. Their other recommendation was to add the patrons of prostitution, second or subsequent violation, to the list of offenses that are eligible for progressive consecutive sentences. We'll talk about that in a minute too. So in sort of my grid of looking at this, there's 4 decision points for the commission to be considering in this. The first is, should prostitution offenses move to the sex offender grid? So the staff and the Central Minnesota Human Trafficking Task Force recommend yes, but it's by no means a slam dunk. There are definitely pros and cons to this question. The pros are that the sex offender grid is for sex offenses, and these offenses are generally sexually motivated. This is most obvious with crimes involving children under age 16. Those are sex offenses, right? I mean, if you have a sex act with a child under 16, you're committing a sex offense. So why does adding the financial layer to it make it not a sex offense? That doesn't seem to make a lot of sense. The cons are regarding patronizing prostitution. So this is not a sex offense without the financial inducement. It's just consensual sex between 2 adults. So why does adding the overlay of a financial transaction convert it into a sex offense? And then there's the concern about engaging in prostitution with a minor. Well, like I said, it's theoretically possible. It's not the typical fact pattern, but it is theoretically possible for, say, a 17-year-old patron to hire a prostitute. That prostitute would be committing the offense of engaging in prostitution with a minor. That may not be sexually motivated at all. So is that a sex offense? So I'll just leave it at that. I guess there are ways of dividing it up that maybe get around that problem, but those are the cons. Overall, those staff thinks that these are generally sexually motivated, so it does make sense to move them to the sex offender grid. The second question is, should the commission make further severity distinctions other than just the 3 different severity levels that are recommended now? Staff does recommend that the commission consider doing this. The Central Minnesota Human Trafficking Task Force is not recommending such distinctions. The reason for the distinctions, the distinction we're talking about are these Clause 3 child prostitution offenses that involve not children, but people believed to be children. Essentially, they involve undercover officers posing as children. And staff's rationale here is that the offense severities are supposed to be based on the harm caused by the offense and the culpability of the offender, basically. And in this case, the offender in Clause 3 offenses are precisely as culpable as offenders in Clause 1 and 2 offenses, but there's no harm to a child in that case. And by the way, offenders may be just as dangerous in clause 1 and 2 offenses as in clause 3. But again, there's no harm to a child because there is no child. It's an undercover officer in clause 3 offenses. It's very much like an attempt to my way of thinking. It's where the person, I had a case where the fellow, had a 6-pack in one hand and a bag of condoms in the other, and he's knocking on the hotel room door and is quite surprised by what's on the other side of the hotel room door. It's not a child waiting to have sex with him. It's an undercover team of officers. So that person, if that were a different crime, would probably be guilty of an attempt. And so I guess that's the thought of ranking these one severity level lower than the clause 1 and 2 offenses where there actually is a child who's harmed. The cons are, even if the harm is less, the culpability and the dangerousness are the same, as I said before. And the legislature assigned the same maximum penalty to all 3 clauses. So the legislature apparently thought these were similar severity. Although I will say there are other instances where the commission has made distinctions between offenses that are assigned the same maximum penalty based on different levels of severity. So that's the second question of should the commission make further severity distinctions. So the third decision point is how should prostitution offenses be ranked on the sex offender grid? Obviously, this assumes that the commission answered yes to the first question of should prostitution offenses move to the sex offender grid, or at least some of the offenses should move to the sex offender grid. So staff's recommendation is to re-rank the severity level 9 offenses at severity level C and D. That D would be for the sting operations, the undercover officers rather than the real children. And I would just say, I think the rational thing to do, if you didn't like staff's analysis on clause 3 offenses, you could just ignore the and D. So just rank the offense at severity level C. And the same thing would be true with severity level E and F. If you didn't like the making distinctions, just rank it at severity level E and severity level G for what's now ranked at severity level 3. So the advantage to this system is it keeps the presumptive sentences within the statutory maximums, consistent with the guidelines grid design. One of the problems with the Central Minnesota Human Trafficking Task Force recommendation, which is to rank severity level 9 at severity level B, re-rank severity level 5 at severity level F, and re-rank severity level 3 at severity level G. And I'll just skip down to that right now. The new presumptive penalties are as consistent as possible with the old presumptive penalty. So it does have that virtue, but it also kind of busts the grid because the severity level B offenses, they are not within the statutory maximums. So it ends up where you don't get an additional penalty as you move across in criminal history, which is how the guidelines are designed to be. So moving back up to the second bullet point, like other sex offenses, this ranks the most serious version in such a way that the maximum presumptive sentence equals the statutory maximum penalty, and that's really how the sex offender grid works. There is one case where this really can't happen because the statutory maximum penalty, I think it's the 20-year statutory maximum penalty, there isn't really a level on the sex offender grid where 20 years is the statutory maximum. So we can't quite do that, but we try to do it as closely as possible to mimic the way other sex offenders are treated on the sex offense grid. And the other thing is there's a rational stair-step-like severity level decrease as severity decreases. So if you follow the staff recommendation to the full, you end up with a ranking for these offenses at C, D, E, F, G, and H. So it just goes down the staircase as severity level decreases. So that's the third decision point. And then the fourth decision point is should repeat patrons of prostitution be eligible for consecutive sentencing? Staff's recommendation here is qualified. It depends on whether you're moving this offense to the sex offender grid. So if you're moving this offense to the sex offender grid, then apparently you believe that the offense is a sex offense, and it kind of implies that it's a crime against a person. Crime against a person is what the list of offenses that are eligible for consecutive sentencing is. Basically, once upon a time, there was no list. There was no section 6 of the sentencing guidelines. It just said if there are 2 crimes against a person, then those are eligible to be sentenced consecutively to each other. But then for legal reasons, it became clear that we needed to spell that out, exactly what these offenses are, because it just involved too many judgment calls as to whether something was or wasn't a crime against a person. So we made the list of offenses that are eligible for permissive consecutive sentencing. And all sex offenses are on that list. So if this is going to be a sex offense, then by inference, you think it's a crime against a person, and so it should be on the sex. If you move this offense, the repeat patrons offense, to the sex offender grid, then you should also put it on the list of offenses eligible for permissive consecutive sentencing. But the con is, if you didn't move it to the sex offender grid, I should have said not in that sentence.
Yeah.
If the offense is not moving to the sex offender grid, the commission presumably concluded that the offense is not necessarily a crime against a person. So then the staff recommendation would not necessarily be to move it to that list. So those are the 4 decision points. That really kind of takes us to the conclusion slide, which is, what do you want us to do now? First of all, does the commission want to continue to work on the issue? As Commissioner Larkin pointed out, this wasn't something that was in the statutory mandate, so you don't have to work on this issue. On the other hand, we did get pretty far along on it. You know, if you're going to work on it, now's as good a time as any to work on it, because you basically, you know, got the car up on the jacks, and you're, you know, taking some parts out. So now would be a good time to fix it if you want to if you think it needs fixing, or you could just say never mind. Let's drive off.
After the jack is lowered, or?
Yeah, well, you do want, we'd have to put all the parts back and lower it, but yes. So if you do want to continue working on it, what do you need to move forward? Do you need more data? Do you need more research? Do you need more stakeholder input? I didn't summarize in here. In addition to the Central Minnesota Human Trafficking Task Force, we did hear from the Advocates for Human Rights. They were important in this conversation back when the commission decided not to put this offense on, the child prostitution offenses on the sex offender grid, right? They were important in that conversation because they thought there might be some unintended consequences for prostitutes who might be sex trafficking victims, and inappropriate to call them sex offenders. But they think that's been pretty much resolved by the legislature, so they're okay with it moving forward as well. That's some stakeholder input that we've also had, and that's summarized in the paper. There's a lot more detail in the paper about all these issues. But I'll shut up now.
Commissioner Knutson.
I think it would be helpful. I mean, the task force recommended us to take a look at it. I mean, it's kind of our job if we get those referrals and we think it's important enough. I think this is an issue that concerns a lot of folks, a lot of citizens, and it's prevalent over at the legislature. Although they didn't ask us to look at this, I think it's something that they might appreciate us offering some suggestions and putting it on the grid. I think it should go on the grid.
Commissioner Middlebrook.
Thank you, Madam Chair. I'm curious, did we ever run any numbers on these? Do we have numbers on
Like
these
that impact?
offenses and bed impact and just kind of overall? I can't remember.
Yeah, I mean, that's, I think we ran some basic frequency numbers, but I don't recall running any bed impact, because I don't think anything got that far to proposal stage.
And what about for the, on the new felony for the subsequent patron of prostitution? Was there that should have probably had a fiscal note, right?
Yeah, that's true. We wouldn't have a lot of data yet because that's such a new
Right.
felony. But yeah, we did do a fiscal note on that. I don't recall what the impact of that was.
Yeah, I just think it would be helpful to get some of the numbers to just kind of see what we're looking at.
Yeah, maybe if we I mean, they would still need parameters for what to run an impact on. So, I mean, maybe it's if we followed staff recommendations. I mean, I'm just trying to like
No,
figure out a
I-
baseline for them.
Yeah, I think, Madam Chair, I think that's true. I know that on the sex offender grid, the numbers jump up a lot as you move across the grid. I guess I was just kind of curious on what we're looking at for numbers based on the staff recommendations. That's what I guess I would be interested in.
Okay. Commissioner Larkin.
I have the same question, sort of, okay, if we're gonna move from one grid to the other, are we gonna just be having the same number for the presumptive sentence, or is that going up? I mean, what does it look like if we move these things lower? Because I do have concerns about the one example, 2 consenting adults. You know, for the child example, for the others, they're already essentially on the sex offender grid because the underlying offense is a sex offense. So I do have a little bit of concern about moving the other one over, and I guess just all the crime we have going on, sort of all the areas where people are saying, why aren't we doing more to crack down on gun violence or carjackings or these other things? It seems a little odd to me to, you know, take steps to, if it were to be the case, increase penalties on prostitution as opposed to increasing penalties on these other offenses. Not to say that prostitution isn't serious, but just on balance, I wonder if it's the most pressing thing and whether that is something that should be on the sex offender grid, given sort of the damning consequences that go with that grid.
And I think I'm hearing you say something a little different. I think that you're asking for a little bit of a different impact analysis than what the staff normally does. Like what they normally do is tell us on balance, will this increase or decrease prison beds? But I think what I'm hearing you say is on balance, will this increase or decrease the actual sentence that they're given?
And so maybe what would answer my concerns would be like, okay, if staff in the past has come to us and said, well, here are the offenses, here are ways you could rank them, and here's what it would look like. That's kind of what I'd like to see. Does that make sense?
Well, I think they've given us here's the ways you could rank them option. And then we had, if I'm remembering the paper right, like similar to what we did with sex trafficking, they gave us like, here's the range for what it is now, and here's the range for if we re-ranked it, so you can kind of see, and then the midpoint sort of where, like, you know, that's one visual way to sort of see if the sentences are similar, but it's not, I don't think quite getting at the level of detail that you think that you want.
But you're saying it's in here in the report, right?
In fact, the page you're on right there.
That's what I'm
Yeah.
And again, it didn't have the benefit of before, okay.
Yeah, no, so, but I'm wondering if, you know, okay, so I'm thinking out loud, so just bear with me. Normally, you guys give us bed impact. The bed impact is really a step after, I think, what she's asking for, which is really what do people ordinarily receive for this crime? Like what's you know, on average, is it a 12-month sentence or a 24-month sentence? And sort of, so if we make this change and move it over there, is that sentence, you know, still on average a 12 or 24-month sentence, or is it something different? Or does it go up by an average of 2 months in every case, or does it go down by an average of 2 months in every case? I don't know. Jill, you know, I don't know if Jill has any thoughts on whether I'm just spewing smoke here, but just trying to get at it.
It's kind of tricky on
Yeah,
the repeat patrons because
right.
that wasn't a felony until September 15th of 2021. So
You don't have data on that one.
yeah, I mean,
So we really would be just looking at the presumptive range for that group.
yeah, I mean, unless we could get some data from the courts, but boy.
Yeah.
That would be tricky.
But the other offenses, some of them are, there's other prostitution with
The
a
child prostitution.
child
offenses,
prostitution offenses. Those might be a place where you could think a little more about how do we get at impact, maybe. Commissioner Middlebrook, and then
Thank you, Madam
Commissioner
Chair.
Larkin.
On the patrons of prostitution, I understand because it wasn't a felony before September of 2021. But do we think we could pull that fiscal note so we could get an idea on, I guess
Objections.
that's kind of what I'm interested in, and I don't know that I have that from back then.
Yeah, we could definitely pull our fiscal note from back then to see what our estimate was.
Yeah.
But, sometimes, some of our estimates we have a great deal of confidence, and some of our estimates are just our best guess, to be quite frank.
One more thing, I think that I could probably get our, for public defender cases, I could probably get a number that have been charged or convicted through our system under that new felony. I would think you could get that from the courts.
We should be able to get that from the courts.
I'm just more curious because they would have been gross misdemeanors before. And so I recognize that part of it, but it seems like we could still get some information on that.
Okay. Commissioner Larkin, you had another comment or question?
Just that, I mean, do we have, could we agree that, okay, well now we've got this copy and we didn't have the benefit before. I'd like to read this and have time to come back and discuss it more.
Yeah, today is like, what do we need?
Okay.
What other information do we need? What would be helpful to, I mean, it's also, do we want to keep talking about it, number one? And then if we do, what do we need in order to continue that conversation?
Madam Chair, if I may, this is
Yes.
not an action item today. This is just for the
Right.
commission's discussion.
Right.
Madam Chair,
Oh, I'm sorry, Commissioner Knudsen.
as part of that, can we go back to some of the folks that gave input on this aspect of the last kind of review? So, I don't know, that we, obviously, public defenders, task force, do you have any other concerns or any other input now as time's gone by? The human rights group or something that weighed in before on this?
Yeah, certainly would you want them to come back to a meeting and just sort of, what are you looking for there?
I think just a written response.
Okay.
To any concerns, comments, suggestions, recommendations they might have with respect to ranking these offenses.
So maybe if we gave them, these are the 4 questions that we are currently considering. We know that we've gotten input from you in the past. Has anything changed? Is there anything else you'd want us to consider or know as we continue to think about this?
I think that'd be great.
Okay. Commissioner Moore and then Commissioner Middlebrook and Commissioner Moore.
Thank you, Madam Chair. Nate, a question. I'm wondering, do we have any data on how many of folks in the scenario that you described from your experience as a prosecutor end up getting charged and convicted of attempted third-degree criminal sexual conduct? Because that's the charge that was being used by the prosecutors in my jurisdiction on these sting cases. These are the undercover officer acting as the 15-year-old, and they were being prosecuted very aggressively, and that was, I believe, sustained by the Court of Appeals, if not the Supreme Court, in the DeGroat case. Remember that, Commissioner Middlebrook? I think it was DeGroat. There may have been other issues. I had that case as a trial judge. So I don't know if that bears on anything with regard to the ranking of this, but if these offenses are already being prosecuted and maybe achieving a higher ranking, might be something to at least consider. That would be for the so-called victimless offenses, with the officers involved.
I really appreciate you saying that because I think that that's what, for me, feels a little bit like the missing piece here is how these cases are handled in the field. And that's actually the kind of information that is helpful to me to know, to hear. So I'm not sure what that means in terms of who we could potentially hear from, but
Right, yeah, I don't know if that's a county attorneys association question, or if that's a, if there's court data that could be obtained, or if that's just those maybe unique charging in one county. I just don't know.
yeah. And, okay. Did you have a response to that?
I did. Yeah, I just wanted to call your attention to footnote 16 on the paper. And that's, we had a fiscal note, well, it was for that bill in 2021. And we looked at the records of the 50 cases sentenced in 2019 for prostitution offenses involving minors from ages 13 through 15. So we were looking at that age group for obvious reasons because they were changing the age. So we wanted to see how many of these cases were going to go from the higher category into the lower category. I'm sorry, from the lower category, from a less severe offense into a more severe offense, because we were interested in those 13-year-old victims. The 13-year-old victim cases were the ones that were going to be elevated in severity. So to do that, we had to look at all the complaints. And so we did get a little bit into the weeds, and this is assuming the truth of the information that's on the complaints, which of course is not proven and so forth, but it's really helpful perspective to get into like a fact-based question such as the one you were presenting, Commissioner Moore. And what's really interesting is that 49 out of those 50 cases involved sting operations with undercover agents posing as children. So,
That was my experience as a judge.
right, and yet they were being charged. So we're talking about children aged 13 through 15, or fake children, if I can use that term. That sounds crass, so maybe I shouldn't use that term. But undercover officers posing as children, they were being charged under the prostitution statute. So I'm not quarreling with the idea that they maybe could have been charged as an attempted criminal sexual conduct as well, but in this case they were being charged under this statute.
Commissioner Middlebrook and then Commissioner Morath.
Thank you, Madam Chair. Just along the same lines, I guess I would be interested too in if there's departures, if we have a breakdown on some of those, or on those cases that were departures because they were believed to be children that are actually undercover, or whatever we're calling them, not fake children, but on the departures, I'd be interested in seeing what the departure numbers are.
Okay. Commissioner Morath. Did you want to respond?
I'm just saying.
Oh, and then, okay, Commissioner Morath, and then I will get to Commissioner Ibrahim next. Thank you for pointing that out.
If we're planning to circle back with key stakeholders on this, I guess I'm wondering if there's any groups, law enforcement, who might be able to speak a little bit more directly to the prostitution cases involving 2 adults, especially given the limited data, unintended consequences, whether it's, enhancing the sentencing penalty, that's going to potentially create, decrease reporting or whatnot. Just things that may not be clear to those who are not directly involved in the field.
So I'm sorry, can you repeat, who you thought we might?
I don't necessarily know who
What
that
types
the
of-
best person or group
Yeah.
that might be, but just any law enforcement came to my mind, but
Okay.
I guess I'm open to whatever.
Okay, Commissioner Nate.
Madam Chair, some of the literature that's cited in the footnotes, and I recognize you could probably spend a few hours reading that paper and chasing down all the footnotes and stuff, but there's a lot of interesting stuff in it if you do have a few hours. But one of the items was one of the items was a paper that was talking about sort of the patterns of prostitution in Minnesota, and it seemed, at least in that paper, as I recall it, that it was kind of a regional thing. Like there'd be regional hubs of prostitution throughout the state. So it might be interesting to follow up with Commissioner Morath's comment to get maybe a law enforcement agent from one of those regional hubs to speak about the pattern of prostitution in that area.
Was that the mapping the demand?
Yeah. Okay. Commissioner Ibrahim.
How you doing? I was gonna mention the same thing Commissioner Marth stated, bringing law enforcement, because I know they have task force or investigators that are assigned to some of these task force that do it full time, who continuously monitor some of the issues of child sex trafficking and things like that.
Okay. Yeah, so maybe you are a contact that could help put us in touch with some folks too. Nate might be reaching out to you.
And I do have a resource who is part of a task force in the metro area, and I can reach out to him.
Okay, great. Anything else? Okay, so based on the conversation, I think I'm hearing, let's keep having the conversation. Let's get more information. And let's all take a few hours and read the paper that Nate has put together for us. And then we can continue this conversation at subsequent meetings.
Should we divvy up the footnotes?
I think that would be a good idea. That is a active learning technique to do the jigsaw. Everybody gets a piece of it and they have to tell everybody else what they read. I think that's a good approach. Okay. Well, thank you. Thanks to everyone for that discussion, and thanks for Nate for organizing our materials on that one. So we have it all in one place. I think that's going to be a lot easier for us to reference going forward. I appreciate that. All right, we'll move on to item number 6, which is the budget.
Thank you, Madam Chair. So the last fall, I came to you with a request to consider making 4 requests of the governor to include special appropriations in his budget request to the legislature. And the governor's budget was released last month, and it did include those 4 requests, all 4 requests exactly as we made them. There are actually 5 change items. The first is called maintain current service levels, which I interpret that as essentially an inflation adjustment, quite possibly in anticipation of negotiated contracts with labor. But the second change item is called expanding analysis of sentencing related data. That would, if approved, enable us to hire a supervisor, and I think really get us moving on a different level as far as our research goes. The second item was, I guess as he's got it, the improving fiscal transparency and agency independence. That would allow us to pay for what we're now getting for free from Commissioner Schnell, which is our human resources and fiscal services, which really we're not supposed to get for free by law. So that would kind of move us to being where we ought to be in terms of fiscal transparency and agency independence. The third change item is fully integrating with the court information system. That would really bring our data efforts into the 21st century. But the fourth item, as the governor's outlined it, is comprehensively reviewing the sentencing guidelines, phase 1. So that is a big deal for the commission. That would involve a comprehensive review of the sentencing guidelines. Phase 1 would be a 2-year phase where we would be involved in simultaneously collecting a great deal of stakeholder information using the Management Analysis Division of MMB. They're experts at collecting stakeholder information. Before they did that, obviously there would be meetings with the commission to analyze how that ought to be done. But they'd have to move out on that pretty quickly. So if this were approved, we'd have a lot of work to do starting in July to organize that. And then while that stakeholder engagement would be going on, there would be simultaneously, the commission would be doing its own research and looking at how the guidelines are working to accomplish what their objectives are. And some of these long-term issues that we sort of hinted at as we've done our data reports, like, boy, you know, mitigated dispositional departure rates sure are high this year. And boy, the presumptive commits keep climbing as a percentage, and looking at some of these long-term trends and really taking the time to unpack them and figure out what's going on. Are the sentencing guidelines working to accomplish their objectives? So that would be, I think, tying up a huge amount of the commission's time. This would involve a temporary research analyst to assist the commission in this work, and would involve some funding for academic support for some higher level research. So it would be a big deal, and it would just be phase one. And the goal at the end of phase one would be to figure out what's phase two going to look like, and what do we need to ask for from the legislature for phase two, with the idea of finishing up within about 3.5 years. So this money has not been appropriated, but by seeing it in black and white in the governor's budget request, it makes it a lot more real. And I think it's something that the commission may want to consider devoting some meeting time to in the spring to talk about, you know, I'm not saying to devote too many resources to it because it hasn't happened yet, but at least to begin sort of a pre-planning process of what would we do if we got these funds, because it is a real possibility now that it's in the governor's budget request. So that's all I had to say on that, but Madam Chair, unless you want to discuss it further.
I don't have anything else for today. Does anyone else have any comments or anything they want to talk about today? Nope. Yeah, we don't know yet. You know, all of the different agencies have to go before the two crime committees to present their budget, and we don't have a date. We don't have an ETA yet, even for that. So,
Well,
but it'll come up very soon here.
I actually got a call late
Oh, you did?
yesterday afternoon, Madam Chair, and they said, "Hey, we got a cancellation this morning. This is the House
Oh God.
cranking. We got a cancellation Thursday morning." I'm like, I think 10:30 is a little close for me. You know,
Yeah.
I have a commission meeting at 1 o'clock. So
You're giving your time to the commissioner of correction meeting.
Appreciate it.
anyway, I mean, I would have tried to do it if I didn't have this commission meeting, but
Yeah.
anyway.
Yep. So it'll be coming up, and then we'll see how those discussions go. All right. Great. Then you would like us to consider another recommendation to the legislature, item 7.
Thank you, Madam Chair. And I know the commission did just make several recommendations to the legislature in its annual report, but there's nothing about the commission's standing mandate to make from time to time recommendations to the legislature regarding changes to criminal law, criminal procedure, and other aspects of sentencing that ties it to a particular timeline. It just says from time to time. We bring these to you as we become aware of them, and it's a little more pressing given that there is a legislative session going on. This has to do with a felony offense that's found in Minnesota Statute 609233. So this statute, there's basically a narrow group of defendants who can commit these crimes contained in the statute. And those are caregivers of vulnerable adults and operators of care facilities that care for vulnerable adults. And the basic crime is a neglect crime. It's a gross misdemeanor, but there's also a felony crime called deprivation. And that felony is what I wanted to talk to you about today, because there seems to be a mismatch between the felony offense and the felony penalty. And I brought this up with legislative staff, and they agree that there's a mismatch, that it's something that should be fixed. And so they, informally support the commission in bringing this to the legislature's attention. But, some things that they're okay just bringing to the legislature's attention, other things they're like, talk to your commission about it and see if they're willing to make a recommendation. So
Make us take the fall.
yeah, well, and not to spoil the conclusion here, but I'm not recommending specifically that you tell the legislature which of the two options they should do. They should just clarify which one they intend, because right now I think reasonable minds can read it different ways. So there's subdivision 1A, which contains the offense, and subdivision 3, which contains the penalty. Subdivision 1A says that if you deprive, again, either one of these caregivers or facility operators, if you deprive a vulnerable adult of necessary food, clothing, shelter, healthcare, or supervision, despite the fact that you're able to provide it, you're guilty of a felony, provided that you meet one of these two alternative ways of committing the offense. One of the ways is where you know or have reason to know that the deprivation could likely result in substantial bodily harm or great bodily harm to the vulnerable adult. Those are terms that I abbreviate throughout the rest of the paper, but basically think substantial bodily harm, broken bone, or something like that. Think great bodily harm, missing body part, or something like that. So pretty high degree of harm. So if the deprivation is likely to result in that kind of harm, that's one way of getting there. The other way of getting there is if the deprivation occurred over an extended period of time. Note that subdivision 1A does not actually require substantial bodily harm or great bodily harm to result. Only one of the clauses only requires that that the deprivation could likely result, and that the caregiver, facility operator knew or had reason to know that. And then if you violate 1A, then you're guilty of a felony and may be sentenced as provided in subdivision 3. So you get down to subdivision 3, and it has 2 felonies. If the conduct results in great bodily harm, up to 10 years and a $10,000 fine. And if the conduct results in substantial bodily harm, up to 5 years and a $5,000 fine. So we have a prosecutor call us, and the prosecutor says, so I've got a caregiver who deprived, or I don't know if it's a caregiver or facility operator, who deprived a vulnerable adult over an extended period of time. So that 1A clause 2 there. But there wasn't substantial bodily harm or great bodily harm. So I'm going off of the theory that because it says is guilty of a felony and maybe sentenced as provided in subdivision 3. Well, there is no provision in subdivision 3 that matches this. So I'm just going to go with the generic penalty for a felony, which is 5 years and or a $10,000 fine, which is an interesting reading of it. And I don't know that it's necessarily an incorrect reading of it. I know that when I ran this past legislative council, one of them was of the opinion that that wasn't the right reading of it. So, basically the way I look at it is guilty of a felony and maybe sentenced as provided in subdivision 3 seems to be at odds with itself. If the person's guilty of a felony, why isn't there a felony penalty provided in subdivision 3?
Yeah.
So what we're recommending is, so there's really 2 different ways of looking at it. One is that subdivision 3 provides another element. In addition to doing what you got to do in subdivision 1A, you also have to inflict substantial bodily harm or great bodily harm, which is sort of implied in subdivision 3, which is a really odd way to write a crime. And the other way is the prosecutor's reading, which is that if you're guilty of subdivision 1A, you're guilty of a felony, but there's just no penalty provided for that specifically in subdivision 3. So what we're recommending is that you recommend that the legislature clarify whether it intends substantial or great bodily harm to be a necessary element of felony deprivation of a vulnerable adult. If it does, then it should add an element of substantial or great bodily harm to subdivision 1A. If it doesn't, then it should have a third penalty tier in subdivision 3 that says, in other cases, 2 years statutory maximum or something like that. Other cases where you violated subdivision 1A, but great bodily harm or substantial bodily harm doesn't result. So that would fix it. Either one would fix it, but the point is it's a little confusing right now.
Well, it sounds confusing to me.
Scroll down to the statute language.
Recommendation.
Scroll down to the statute language real quick, because I think that is a little bit, for me, it's always easier to look at the actual statute.
Okay, and 1A and 3 are kind of separated from each other, so.
Yep. So this is the definition of the crime. It's a felony if you deprive care, if under 1, you know or have reason to know it could likely result in substantial bodily harm or great bodily harm, or number 2, it occurred over an extended period of time. So I think the penalty deals with the harm in 1, but not the substantial period of time into.
Well, it's
That's
possible harm.
It
One
I know, I
doesn't
know.
require harm, it just requires a risk.
doesn't require harm at all, you're right. It's just that you have reason to know
Mhm.
that it could result in harm. Yeah, it's not very well written. The penalty is not written to address the actual offense. Sorry, Commissioner Knudsen, I cut you off. What were you going to say?
No, that's all I was gonna say. Catherine? Yes.
Commissioner Middlebrook?
Well, I was going to say the exact same thing you were, Madam Chair, because that was how I was reading it. It's really a badly written penalty. I mean, the whole thing is bad, but it doesn't make any sense in how they describe the penalties, because they do leave out the second paren too. What's the penalty for that?
Right.
Otherwise, it seems to me it's a gross misdemeanor, but there is that additional fact that seems like it's missing that they have to find.
Mhm. Yeah. So, would anyone like to make a motion that we recommend that the legislature clean this up? We don't have to tell them how, we just have to tell them, we point out the problem and explain that they should fix it.
I move, because I think, at the end of the day, if we have to decide how to rank these things and we can't figure out what it means, how would we do our job?
Right, so Commissioner Larkin makes a motion to essentially recommend that the legislature change the penalty to better address do you want to say something?
We remand it to the legislature.
Oh, that's fun. I don't get to remand things very often. I like that.
Madam Chair, to clarify, is that consistent with the staff recommendation? Because we're basically giving them two options. You could either change 1A to include an element of substantial bodily harm or great bodily harm, if that's what you want, or change 3 to include catch-all, a third tier penalty, or are you not getting that specific?
I don't think we should get specific.
Just fix the mismatch, basically?
I think so, because, they are supposed to say what the sentences are, and then we're supposed to figure out how they fit into the guidelines system, right? And it's like kind of going too far if we start telling, well, here's how you rewrite this and to accomplish things, right?
Yeah, I think it sounds like the motion is for them to fix the mismatch. God, I can't say things today. And when we call it out to them, we would describe the problem that we're seeing. Do we have a second for that?
Second.
Commissioner Knudsen seconds. Any further discussion? All right, then we'll take a vote on that.
So,
Commissioner Knudsen.
so you talk about fix the mismatch. Can we add some other language to that motion? This is just too,
I think he'll, go ahead.
to clarify
The
and
intent.
the intent and determine the appropriate penalties for this offense.
Commissioner Larkin, do you accept that as a friendly amendment to your motion?
accept that. Thank you.
All right, perfect.
All right, so how about this?
Jigs aren't up.
So the commission recommends that the legislature clarify the elements and penalties of the offense defined in Minnesota statute 609233 subdivision 1A and penalized in subdivision 3. Does that sound about right?
Say that one more time.
So that the commission recommends that the legislature clarify the elements and penalties of the offense defined in Minnesota statute 609233 subdivision 1A and penalized in subdivision 3.
I think that sounds good.
I'm sorry, who seconded the motion?
Commissioner Knudsen. Larkin, Commissioner Larkin was the bringer of the motion, and Commissioner Knudsen seconded.
To the Larkin motion to recommend that the legislature clarify the elements and penalties of the offense defined in Minnesota Statute 609233 subdivision 1A and penalized in subdivision 3, Estrada. Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd? Ladd absent. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. And then I'll also say, we have a couple of other sort of outstanding recommendations that we've made to the legislature recently. I know they're not, biting, they're not like running to fix them because they're all technical things that we've all, that we have uncovered. But one of them was clarifying the minimum sentence for murder of an unborn child. And unfortunately, we recently almost had that situation happen in Minnesota. So I think it's really important that we get some of these technical issues cleared up. So I've asked Director Rice to send an email to the chairs of both committees in the legislature to remind them of the past recommendations that we've made. And so he'll have a double reason to contact them now, because he'll contact them with this new change and then also remind them of those couple of prior recommendations that we've made.
Thanks, Madam Chair. And I might just send it out to the whole committees, actually, if that's okay. That was what I was thinking anyway.
Yeah.
Okay,
That works for me.
great. All right.
I know that that's not the first bill that a legislator wants to draft, is the corrective bill, but we don't have the authority to draft a bill ourselves. So we've got to get these things moving and get our statutes cleaned up especially when these things are not controversial. Okay, so that does move us to the legislative update sections, talking about the legislature, and Nate is starting to catalog and keep track of the number of bills, so I'll let you go through that.
Thank you, Madam Chair. Just pull it up, and I should let everybody know, in case you downloaded the meeting materials early, that the first 2 documents here are dated February 8th. So I did update these yesterday. So if you're operating off of a version that's February 2nd, it's going to have some missing information. So the current version is on our website. So the first document is bills directly related to the commission. Now these bills, the second document has sort of a viability requirement that something is happening with them. Typically, it's that we've been asked to prepare a fiscal note, and so it's got some indication that it actually is a live bill. These bills may or may not be live, but they bear so directly on the commission itself or on the application of the sentencing guidelines that I thought the commission might want to know about them. And for all these bills, whether it's these bills on this paper or on the other paper, the commission's standing mandate to make recommendations to the legislature regarding criminal law, criminal procedure, and other aspects of sentencing would apply. So if the commission has, these aren't on as an action item, but if the commission has any recommendations that it thinks the legislature ought to consider, now would be a good time. As is indicated on this paper, the first committee deadline is March 10th. So the first committee deadline is the deadline by which non-budget bills has to have been heard and passed out of the committee in the House of Origin, and then usually the second deadline is a week later. So things are moving pretty fast as far as the legislature is concerned. And a lot of these bills don't have a big fiscal impact, so they would be subject to that first committee deadline. They're not going to be part of a big budget bill, or at least in theory they wouldn't be. So the first one is prosecutor must initiate post-sentencing action to make a mitigated adjustment to a sentence. And then the commission has to annually summarize and analyze sentence adjustments for the legislature. Next one is we have to post audio and video recording of each meeting on the internet. We have been doing that since we went to hybrid meetings during COVID. But this would basically require us to do what we're also doing. Also, it's possible that, the chair might want to have a workshop or something like that where everybody has to come in person. And then I think we'd have some technical issues because we wouldn't have the same hybrid setup necessarily. So there might be a physical cost associated with this to buy the equipment to still have to audio and video record the meetings that weren't being broadcast. Because right now we're just taking the WebEx technology by which we're operating the hybrid meetings. We're recording it and putting that on the internet.
Commissioner Larkin?
If the chair wanted to have such an in-person workshop, why couldn't we still use WebEx? So the public could watch the workshop and then to eliminate that cost.
It's possible. I mean, I don't think the cost is that significant. I think what it would do though is free up the chair. And I'm not suggesting the chair is intending to do this. I'm speaking hypothetically. But it would free up the possible location. It wouldn't have to be, I mean, this particular room we're using this room primarily, thanks to the generosity of the Commissioner of Corrections. We're using this room because it's got excellent audio visual. It's able to, there's a robot cameraman right now that's zooming in on me. And so it's the technology that's in this room that makes it terribly useful for hybrid meetings such as the one we're conducting right now. But maybe this room wouldn't be the best facility for a workshop. So maybe the chair would want to meet at a meeting room at a restaurant or something. I have no idea. And so we need to bring in technology to work that out.
Commissioner Larkin?
Would a workshop be like our roundtable that we have at the Judicial Center, which have remote technology? I mean, I'm just having a hard time imagining the example, like in terms of meeting at a restaurant. I mean, wouldn't that violate the open meeting law?
Not as long as people could come. He's just doing hypotheticals, and really it's like, I think all he's saying is if it limits where we could hold it because of we would have to have the technology available to record it in that case. Yeah.
So the next bill, if this bill actually, I would probably testify on this bill, not giving it an opinion of the commission, but just from a staff point of view. I'm thinking of maybe a different. So the county attorneys must report reasons for all felony dismissals to the commission, and the commission must annually summarize them. Actually, I'm thinking of a different bill. It's House File 930. It's 2 bills down, where the county attorney firearms case reporting requirement expands to include case-specific information and posting that information on the commission's website. So we're supposed to provide a report on data that we don't get from the county attorneys. So I would testify that we don't make up data, and I don't know how we would do that because it doesn't change the county attorney's reporting requirements. They don't have to give us case level information. They just give us a roll-up of all their cases and we report it. So there's a little bit of a mismatch there in that bill right now. The one before that I skipped over that would require, right now, if the commission proposes a change to the sentencing guidelines, that change will go into effect unless the legislature by law provides otherwise. This would say it will go into effect only if the legislature by law adopts it. So it kind of flips that on its head. The House File 931, Senate must confirm governor-appointed MSGC members. 1075 requires us to have a data dashboard on our website, which would be pretty cool and pretty expensive. And also, just to the judicial branch members, I think there's a possible concern there that that data might be misused to misrepresent what judges are doing in terms of their sentencing behavior. Is it, a judge in one county might not see the same kind of caseload as a judge in another county, here. A judge, in a large county with a particular specialty of caseload might not see the same type of cases that a different judge in that county might see. So there's a concern that making this data searchable and easily accessible would engender a tendency among the public to mischaracterize what a judge is like in terms of being a sentencer. But having said that, if we were told to do this in this bill, we would certainly do it, provided funding were made available. House File 1232 is the only bill here that doesn't have a companion in the other body. It would require mitigated departure factors to be proven to a jury beyond a reasonable doubt, in the same way that aggravated departure factors are now required to be proven to a jury. And finally, there's the Minnesota Rehabilitation and Reinvestment Act, which incentivizes compliance with individual rehabilitation plans by reducing the time that the prisoner would be spent imprisoned or on supervised release. So that's currently not part of law. Essentially, the prisoner will serve 2/3 of the sentence unless the prisoner misbehaves, in which case that would decrease the supervised release time and increase the time spent in prison.
It's being heard next Thursday
Is that right?
in the House, yeah.
Okay, I didn't know that. I wasn't aware that any of these bills had been set for hearing. The next paper talks about the bills. Most of these bills we've done fiscal notes on, with one exception. There's a misdemeanor, gross misdemeanor. It has to do with a Supreme Court decision last year that narrowed the definition of aperture in the what's the name of the statute? The invasion of privacy, basically, and surreptitious intrusion is what it's called. And the Court of Appeals about 20 years ago broadly defined aperture to include a camera's lens is an aperture, and so that pretty much encompasses quite a bit of what happens in modern day technology. And this the Supreme Court case narrowed it down, so this bill would basically broaden it again. And that's why there's no impact. As we analyzed it, we just said, well, it's essentially restoring the status quo to the way it was prior to McCrum's being decided. The next one is the big cannabis bill. It's very, very complex. It legalizes or decriminalizes many instances of marijuana sale and use. It provides both automatic and discretionary retroactive application processes, so that's interesting. There's also expungement processes. It's moving through many procedures. Our estimate is that it would decrease the number of prison beds required by 38 beds. There is a bill that amends labor trafficking definitions, and the House version includes a Sentencing Guidelines Commission's legislative recommendation on one of the labor trafficking definitions that's found in sex trafficking, but it's not really cross-referenced. So this would insert that cross-reference. I don't know if that's been proposed yet in the Senate version or not, but that was supposed to get a hearing yesterday, but it ended up getting bumped because they were trying to fit too many bills in one hearing. The House File 30 is a catalytic converter bill that did move through the Senate Crime Committee yesterday, and it's already moved through the House. So basically, an unmarked catalytic converter has to be marked with something that shows what car it came from, and it sort of tightens up the used catalytic converter market. We don't know if there's going to be any prison bed impact to that. The next bill adds a few more person offenses to the long list of qualified domestic violence related offenses. Prior convictions of qualified domestic violence related offenses enhance misdemeanor assault and protective order felonies to protective order offenses to gross misdemeanors and eventually to felonies. We think there's going to be a 5-bed prison bed impact to that. The next bill establishes felonies for the owner of an unsecured firearm if somebody else uses that firearm in a felony crime of violence or uses it to inflict substantial bodily harm, great bodily harm, or death to someone other than the owner. So as we're interpreting this bill, if somebody leaves their firearm around and somebody else, say, commits suicide with it, which isn't terribly uncommon, that would be a felony. but we're only estimating a 1-bed impact to that. Next bill really has to do with requiring firearms transferee permits for private party transfers and increases the penalty for lying from a gross misdemeanor to a felony. Right now, there's limited use for firearms transferee permits, but that'll probably expand in the bill. House File 803 assigns numbered clauses to the 3 most severe ways of committing kidnapping, unsafe release, great bodily harm, and youthful victim. The sentencing guidelines now assign different severity levels to those 3 different ways of committing kidnapping. This is an example like I was talking about earlier. Sometimes the legislature only has 1 penalty, but the commission defines multiple severity levels for that 1 penalty. In this case, they're all grouped together in 1 paragraph, but the commission still assigns different severity levels to that, which is not normal. This would sort of make that. This really, I think, in my perspective, conforms the statute almost to the sentencing guidelines, which is usually the other way around, because it breaks up these 3 different ways of committing the offense, which the sentencing guidelines now assign different severity levels. And this got a hearing. It was disclosed at the hearing that this is going to become the vehicle bill for the public safety omnibus bill. But personally, I hope it stays as policy as well. It's not gutted by the omnibus bill. House File 450. So this is the most impactful bill in terms of prison beds. This we're estimating, and I'm not saying that we're terribly certain about this number, but we are estimating 69 beds. So basically, it takes shoplifting and calls it organized retail theft, but it's a little bit misleading. It doesn't require an organization of multiple people or anything like that. I'm calling it sophisticated shoplifting. So it's shoplifting where your goal in stealing this isn't to be the end user of whatever it is you're stealing, you or your family. It's where you're going to sell the stuff on eBay, or you're going to return it to the store for money or something like that. That's organized retail theft, and it's basically more serious than existing theft statutes. There's also a burglary offense for shoplifting within a year. So say you get a trespass notice and you're told not to leave and not return, and then you return to the store and you shoplift from there. That's going to become a burglary. Apparently, some jurisdictions are prosecuting this now as a 3rd-degree burglary. The bill would make it a 4th-degree burglary, but it would also make it a 3rd-degree burglary if you have a prior record for theft, which I'm guessing you probably did. If you were trespassed from the store, you might have gotten a theft conviction out of that. But we're estimating 11 beds for the burglary and 58 beds for the sophisticated shoplifting.
I thought I thought the organized retail theft, I mean, I didn't watch the hearing or anything, so I don't know what they said, but I thought it was aimed at like the operation, like there were a spate of robberies where a group would sort of run into Best Buy, take everything and run. I thought it was aimed at that activity, which is, arguably more serious than somebody, picking up something and walking out.
That was last.
As an
that was
individual.
year's
Last
bill.
year, those were happening. There was a bunch of those.
That was last year's bill too, I think.
So this is different than that bill, you think?
Yeah, this is my understanding that this is really about almost like the conspiracies to steal for the purposes of profit.
Okay, thanks. I just want to make sure I was understanding the behavior that we're after. Okay.
I will say, I've gone on national sites that deal with organized retail crime, and they define organized retail crime. And what this bill criminalizes is not organized retail crime by that definition. This bill criminalizes sophisticated shoplifting. So it's where you're stealing something and you are, I think probably the easiest way to commit this bill is people steal something and then they come back to the returns counter and they say, hey, I lost my receipt, but I need to return this bottle of detergent. Or people put it on Facebook Marketplace or something like that. But it doesn't need to involve an organized conspiracy.
Organized retail.
Yeah, there's a little bit of a
Oh,
mismatch.
wait,
With organized retail theft, it typically is not just a group of people doing it. It can be a specific person doing it back to back to back and knowing the system to kind of con the system, or doing that robbery at Target and Best Buy last year that happened. Because I worked in retail for a year and a half, just investigating retail crime. Shoplifters who are consistently coming back doing the same thing. Even if you trespass them, cite them, they still do the same thing. And they do sell a lot of the merchandise either to a third party online or on the street.
Thank you. That's really helpful.
All right, so the next offense has to do with fourth degree assault. Fourth degree assault is sort of like regular assault, but there's something special about the victim, basically. Law enforcement, for example, or crimes involving bias are the two big examples. One of the categories that's now protected are emergency room workers. This expands that protection to include all healthcare workers, even not in the emergency room. So that's a pretty big expansion. We're only estimating 2 beds though, because the offense is not that high severity as far as the commission ranks it. House File 43 is interesting. So basically there's a immigration law change, federal immigration law change in the 90s that defined aggravated felony for purposes of deporting non-citizens to include offenses that have a number of offenses that have a 365-day maximum penalty. And I have a separate paper about this because the current version of the bill, it was amended in committee, solves this problem by redefining what a felony is in the state of Minnesota. So that a felony is redefined to be an offense with a penalty of 365 days or more. And some of the implications of that, I'm not sure I know what all the implications are of that. I have a few different implications in this other paper. One of which has to do directly with the sentencing guidelines in terms of current policy, which maybe the commission could change, but it would have to think about this. But current policy for out-of-state convictions that have, for an out-of-state conviction to qualify as a felony on the sentencing worksheet, it has to be a felony in Minnesota law, and it has to have been sentenced, it has to have received a felony sentence in that other state. So the example that we have in the commentary is a guy from Texas, I don't know if he's a hypothetical defendant from Texas who got charged with assault with a dangerous weapon in Texas, so that's a felony under Minnesota law, but got a 365-day sentence, so not a felony sentence under Minnesota law. And that person in the commentary then would be treated as a gross misdemeanor in criminal history. But with this change, a 365-day sentence is a felony in Minnesota law. So that would become a felony in criminal history unless the commission were to change the sentencing guidelines. Another implication is just, I'm concerned about judges who maybe don't know about this change. It's effective immediately. A judge sentences a defendant to 365 days in jail on a felony, thinking that the judge is giving the defendant a break, but in fact, the judge is committing the defendant to the Commissioner of Corrections. So it's not a gross misdemeanor sentence, and by the way, not a local sentence. It'd be a Commissioner of Corrections commit. So I had some concerns. I talked about it to the author of last year's bill, wondering why he changed the bill. And he said, it's not my bill anymore. Got to talk to the current author, but I didn't really want to talk to the current author because it's not my role, it's your role to make legislative recommendations. If you have concerns about this, you should let the legislature know. So
Commissioner Larkin, and then Commissioner Middlebrook.
I'm just confused. Okay, how did we get to the point where we're saying 365 is treated as a felony?
Depends what the bill's.
If
That's
this
what the
bill
bill says.
passes.
That's not what this bill is.
It is.
It's
As
still-
amended.
Because I'm not understanding that. I apologize.
364 is a gross and 365 would be a felony.
Yeah,
Why are they doing that?
Because of some
Immigration.
immigration.
Yeah.
it's a 365
Oh, I see
sentence
what you're
triggers
saying. They're
immigration.
trying to avoid 365
being
is
felony.
deportation, and they're not recognizing that by doing that, they're making 365 a felony. So it's an unintended consequence?
Well, no, the original language of the bill just changed the gross misdemeanor definition, basically. And
To
then
say-
to say it's a 364.
Okay,
And then, but then a question arose, well, what is it if the judge gives a 365-day sentence?
Well,
So they redefined felony,
Madam Chair, if I can,
365.
so a felony, may I just clarify something? So I've got a separate paper on that
okay.
in your meeting material. So as introduced, and this is the question that I had for the author, last year's author, because I was like, well, what happens if a judge sentences somebody to 365, a felony to 365, which under current law would make it a gross misdemeanor? What happens to your 364-day gross misdemeanors under that? And he said, look, we're not changing the definition of a gross misdemeanor. Gross misdemeanor is not a felony, basically. It's defined in the negative. So since a felony is more than a year and a day, a 365-day sentence would still be a gross misdemeanor sentence.
Yes.
But the law wouldn't allow a 365-day sentence for a gross misdemeanor anymore. It would only allow a 364-day sentence, which I grant you is confusing, but I don't think it's any more confusing than, say, a stay of imposition converting to a misdemeanor or something like that. I mean, we have other concepts in this area of criminal law that are equally confusing, but still workable. But the amendment, I think, makes it clearer, where it just says a felony is 365 days and a gross misdemeanor is 364 days. It makes it clearer, but it also perhaps introduces unintended consequences, such as the one I was describing.
But when you say, Matt,
Yeah, sure.
a felony, it makes it clear that a felony is 365. A felony isn't 365. A felony is a year and a day, right?
Not after
This
the
would
bill.
change that.
This would change it.
Have to change.
So the bill redefines felony. That's the point.
Should be anything sentenced at 365.
It
Do
would
they
be,
know what they're doing?
so
Sorry.
Well, Commissioner Middlebrook, why don't you jump in and then we'll go back if you still have questions.
So what the definition for felony is going to be is a year or more. So it would encompass 365. But I think one of the things that they haven't done, they're going to have to go through the whole criminal code, because there's a lot of places that talk about more than a year or a year. I mean, there's a lot of references that they haven't considered. And I know that they're trying to get this to comply with the federal definition, because that's what they use on the immigration side for an aggravated felony is a year or more. It's a year or more. So 365 falls into that category. And the 364, if the judge sentences to that or less, it's fine, but not all of them are doing that. In the old cases, they didn't either.
No, they just did 365.
Yeah.
Commissioner Larkin.
So can we tell them, don't think you've stared this down, and we don't think you appreciate all of the areas within the criminal code and all of the rules and all of the case law that talks about 365, and this could be chaos. So just, I don't know what you do.
Yeah, and there's one, I know that the current bill has a reviser's instruction to go through and make changes to the code. So I think that they'll pick up on a lot of it that way. But I don't know what else, what else we could say. Not Commissioner. Hey.
Madam Chair, so so procedurally, this was amended in committee, basically at the last committee stop for each bill. I wasn't even aware of it. I talked to the executive director of a large association that represents county attorneys. The day after the second stop, I guess that would be the Senate stop. And I ran into him in the hall in the Capitol, and I said, what'd you think about the redefining of felonies? And I don't know if he gave me a verbal response, but his response was indicative of somebody who had not heard of the issue, which seems to me odd that the term felony would be redefined and some of the largest stakeholders would not be involved in it. I think this was being looked at probably more from an immigration point of view than a criminal law point of view. And I'm not saying it's bad policy or good policy. I'm just saying I do have some, I think they're probably stakeholders. And I don't know about, you know, the defense attorneys, if they were involved in this at all, but it's,
Well, I don't think it's our place to suppose that people were or were not talked to.
Yeah.
I think, you know, you don't always know what the conversations are. So I don't think we should go down that road, but I thought I saw another hand. Did I see another hand?
Am I right that there's the retroactive provisions in there, so anyone would be resentenced?
Yeah,
Is
what,
that-
if
am
I
I right on
recall
that?
how it's written, a person could go back for resentencing to the 364.
Oh, my God.
Have fun.
But they don't have to. I think the law is written to say it just is 364.
yeah. Yes, there are those provisions. And I don't know if that's another, I don't know if the courts have, I mean, I know the court's computers assume a felony is a year and a day. So I don't know,
Oh, yeah, they'll have to fix that.
I don't know if there's a fiscal note on this for the courts. So I don't know.
Or the like, the resentencing part of it?
Well, so the redefinition of felony is not retroactive. It's immediately effective the day after signature, but the requirement to sentence a gross misdemeanor to no more than 364 days is effective immediately and retroactively, I believe. So, and I will say procedurally, this is through committee, it's on the floor of the House, and it's on the floor of the Senate. So it could be enacted into law at any time.
I was just wondering about the Rule 2703 consequences of, I mean, you can claim it's not retroactive, but I don't know if that's the end of this discussion, frankly. I think there's, that has a lot of potential, as we say, downstream consequences on a lot of people. I mean, I dealt with this issue all the time at Worthington because I had lawyers asking for 364-day sentences for years, and generally the prosecutors didn't disagree with that. But to claim that 365 is a felony that's another problem, I think. Just thinking about loud. No legal advice.
Commissioner Middlebrook.
Thank you, Manager. I mean, one consideration I think that we would have to do as a commission, because it does, you know, for criminal history purposes, Nate's brought up the out-of-state situation, that obviously came to mind right away. But even for in-state criminal history, what's used, I think we would have to make a comment or something, because it can't really be applied retro. I mean, it can't be an ex post facto so that those gross misdemeanors are now felonies for criminal history purposes. I think that would be a problem, but it's going to be messy. It's going to, you know, so I think we're going to have to address that
Yeah, we don't have
to give some guidelines.
He hasn't thrown the bill up on the screen, so you don't see the language in front of you, but you know, my reading of the bill is if it was a gross, it's still a gross. If it was a felony, it's still a felony. The difference is going forward, you cannot impose a 365-day sentence for a gross misdemeanor. That would now be the start of the felony sentence range. So, you know, and also the guidelines, apply, you know, considering the law that was in effect at the time. So I think past history, if it was a gross, it's still going to be a gross under our guidelines, but we are going to have to figure out how to deal with this going forward for those out-of-state offenses. I mean, if this passes, we definitely will need to take another look at that policy and figure out the impact and if we need to make any changes. For sure. Yeah.
So my intent is to say no more about this after today if the commission doesn't give me any direction to do so.
Madam Chair,
Commissioner Knudsen.
I mean, we can sit around and talk about it, and Nate can informally go to it. I don't think we have a role to officially play or to render any advice to the legislature other than behind the scenes to, especially the Senate and House Counsel of those committees,
Mm-hmm.
just to point out the issues.
Yeah.
I think they'd appreciate that.
Yep. And I believe that's already been done. I mean, we did that.
Mhm.
Yeah.
Yeah, I'm,
We're also past hearing stages at this point. There's no hearings to testify in. So I think you have already pointed out the issues that this potentially creates with the guidelines. I don't know that there's anything else to do.
yeah. Unless there's a fiscal impact, because nobody's asked the judicial branch for a fiscal note, I don't believe. Because I don't think it had a stop in Ways and Means. So,
Again, not our,
yeah.
going down a path we can't do anything about. All right, was that the last one or
No,
was
it
there
wasn't.
any more?
Sorry, we got a little.
Got a little sidetracked, yeah.
Let's
I mean, it's an important discussion.
see. So, yeah, back to the bills. So, yeah, we added one more. This is the biggest change from the version on February 2nd to the version on February 8th. There's a gross misdemeanor felony crimes for deep fake sexual images. Those are computer generated images that are indistinguishable from reality. And this offense is modeled after the revenge porn statute. We didn't really know what the impact would be, so we estimated that it would be similar to the impact of the revenge porn statute. And since the revenge, look at the year at least that we were looking at it, there weren't any prison commits for the revenge porn statute, so we didn't assume any prison beds resulting from this. There's one other bill that we were asked to do a fiscal note on since I wrote this yesterday, and that is it's a recommendation from the Aiding and Abetting Felony Murder Task Force, which I was actually a member of, that reported last year, to require a higher state of mind for somebody who's aiding and abetting felony murder. And that would have some retroactive application to it. And we recommended a prison bed savings as a result of that, of somewhere in like the high teens to low 20s in terms of prison beds. So that concludes my legislative update, Madam Chair.
All right, any other discussion or from the commission, any other?
We were just
questions or
discussing
concerns?
what deep fake means.
Commissioner
Trying to
Milberg?
figure out what deep fake meant.
I think we should do a deep fake video of Nate talking about
Let's not.
How about singing a Burl Ives song?
Oh, yeah. it's going right. Okay. Time to move on, I think. You're on all day today.
I apologize
Executive Director's report.
for those who have to hear me. So I don't have too much to report. I don't have any information on any more recent information on when the governor's going to appoint the new commission. I will say that the National Association of Sentencing Commissions has announced the date of the the dates of the conference this year, it's going to be in Lake Tahoe, Nevada, August 7th through 9th of 2023. And expect that we'll have some funds to invite some commission members as we have in the past. That concludes my report, Madam Chair.
Great. That, unless there's any other business, I think we are on to public input. Let's do that.
All right. So if any members of the public would like to make a statement, please raise your hand at this time. If you're participating by, looks like everybody's participating by computer, nobody on telephone today, so you should all be able to raise your hand. I'm seeing Matt Majowski is probably going to talk to me about Girl Ives. Not seeing any other hands raised, so I'll unmute Matt to start with. If anybody else would like to make a comment, raise your hand at this time. All right, Mr. Majowski.
Madam Chair, no, I appreciate the the reference. I'm glad it's in your memory. Thank you. You're Matt Majowski, Dakota County Probation, not representing Dakota County, speaking really for myself. I've just figured I would just add a comment concerning the gross misdemeanor bill, since our probation officer representative is not at the meeting today. Yeah, I think that if that passes, it's going to be a big mess, especially for a while. We as practitioners will adjust, but everybody's got to know it's going to take a while. And I think PSIs, worksheets, whatever, there's going to be a lot of errors, mistakes for a while until everybody adjusts to this. Gets it in their head that 365 is now considered a felony. It would be nice if this didn't pass, but it'll be we'll treat it as another challenge for us that we will endure if it does. Thank you very much again for all your work.
Thank you for your comments. Does anyone else wish to raise your hand and address the commission?
Not seeing any other hands raised, Madam Chair.
I am not seeing anything else either. So that brings us to the end of our agenda for the day. I'm going to guess our next meeting is on the same day next month. So let me just check. Yep. So our next meeting is scheduled for March 9th, 2023, just as a reminder. Other than that, I think we have finished all of our business for today, and I will adjourn the meeting. Thank you all for coming. Thanks. Oh, I was going to close my computer without logging out.